Major breaking news out of the United States Supreme Court. Joe Biden and Merrick Garland may have made a terrible strategic blunder for the anti-gun community. They have sought certiorari in the Brian Range versus Merrick Garland case out of the Third Circuit en banc decision that says that nonviolent felons do not lose their gun rights under Federal Criminal Statute 18 U.S.C. 922G1. Now, you may have heard 922G quite a bit recently because, yes, indeed, it touches fingers with the Rahimi case, and that's why you're going to see this could have been a strategic misplay by Merrick Garland. And good news for the Second Amendment. Stay tuned. We'll talk all about it. Hey folks, I'm Mark Smith, host of the 4Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Maybe I need to add a new edition: What the Ukraine War Teaches Israelis About the Right to Bear Arms. Anyway, we'll talk about that later. All right, folks, so major breaking news. Merrick Garland waited till the last possible day to seek certiorari of the Brian Range versus Garland or United States case. Just to jog your memory, earlier this year, in Pennsylvania, Philadelphia, the Third Circuit Court of Appeals, that covers states of Delaware, Pennsylvania, New Jersey, found in an en banc panel, meaning all the judges of the Third Circuit sat together, and concluded that nonviolent felons, those convicted of felonies as defined by federal law but are not violent, do not lose their right to keep and bear arms under the Second Amendment, notwithstanding the fact that if you read federal criminal or federal gun control statute 18 U.S.C. 922G1, the so-called felon in possession statute, it basically provides that if you're convicted of a federal felony, something that's labeled a felony and you can go to jail for more than 1 year, even if you don't go to jail for a day, the mere fact that you've been convicted of something where you could have gone to prison in federal court or in the federal system for more than a year constitutes a felony. You lose your gun rights for life. Likewise, if you're convicted of a misdemeanor where you could go to prison in state court or in the state system or any state system for more than 2 years, guess what? You lose your gun rights for life. That is defined as a federal felony for the purposes of 18 U.S.C. 922G1. Now, we've talked about how I thought it was a travesty and a miscarriage of justice. No shock out of this Department of Justice for Joe Biden, run by milquetoast moderate Merrick Garland. Remember the guy nominated to replace Justice Scalia by Barack Obama, labeled moderate Merrick Garland. Milquetoast Merrick Garland. You can count on him to do the right thing. Thank God Mitch McConnell and Chuck Grassley kept him off the Supreme Court and we got Neil Gorsuch instead. And thank God Donald Trump was elected in 2016 and not Hillary Clinton. But I digress. As you recall, Merrick Garland had a choice. He could have sought certiorari this spring in 2023 of the Range case, which involved a man, Brian Range, who was convicted of a misdemeanor under Pennsylvania state law for lying on his form to get a food stamps, if you will. He failed to disclose, I think, something like $500 worth of income from a lawn mowing business that he did not disclose to qualify for food stamps. When this was uncovered like 20 some odd years ago, he pled guilty and was convicted of this, never spent a day in prison, and has lived a perfect life for all intents and purposes under the law since then. Nevertheless, because under that state statute in Pennsylvania, he could have gone to prison or jail for more than 2 years. That qualified as a felon. He lost his right to keep and bear arms under 18 U.S.C. 922G1. He brought a civil lawsuit challenging this law on Second Amendment grounds, and ultimately, long story short, the Third Circuit, in an en banc decision, said indeed the Second Amendment's right to keep and bear arms was violated by denying Mr. Range the right to keep and bear arms, in the same way that it would violate the right of Martha Stewart, the right to keep and bear arms, because again, she was convicted of lying to the FBI many years ago, and there's no suggestion that Martha Stewart is dangerous or physically dangerous at all. And essentially what the Third Circuit said, for all intents and purposes, is that for you to lose your right to keep and bear arms, you have to be a physically violent danger. You have to be dangerous in some way. It cannot be something that you've done that the legislature thinks is a no-no, is not law-abiding, is not responsible, or not virtuous, that is not sufficient. As you know, the other side, the anti-gun side, wants to declare anything and everything to be a basis for taking away your gun rights, such as a speeding ticket, jaywalking, failing to recycle in the proper blue bin versus another color bin, let's say, or any other whole list of nonsense laws that are out there, the tens of thousands of crazy nonsense laws that even a high-end lawyer such as myself cannot possibly know them all, and I know a lot, but it's impossible for me to even know all the various laws in the United States, and many of them are kind of crazy, insane. As you know, they're malum prohibitum crimes, meaning they're not inherently evil, such as murder, rape, robbery, battery, and so on. They are just crimes because someone says 16 inches is too short and 18 inches is perfectly fine, and it's just arbitrarily selected. That's why they're called malum prohibitum crimes, and there's a whole bunch of those out there that, if the anti-gunners have their choice, will be a basis for taking away the gun rights of millions of Americans if they can pull it off. Now, the reason why I think Merrick Garland has just made a mistake is this. Again, in the spring, he had a choice from seek and certiorari in the Range case, which I just described, but that was very favorable to the Second Amendment community, versus the Rahimi case, where Zaki Rahimi, at least based on the allegations in the court file, appears to be somewhat of an odious character. Now, here's the key, though. What I thought was sort of offensive about the fact that Merrick Garland just shamelessly pushed forward Rahimi is because if you look at the statistics, 18 U.S.C. 922 G8, which is the Rahimi case dealing with domestic violence restraining orders, you will see maybe something on the order of magnitude of 25 to 30 convictions all across America in any given year. That's all of America. 340 million Americans living here. And 18 U.S.C. 922 G8, dealing with domestic violent restraining orders, mean if you have a firearm in your possession and you're subject to a state domestic violent restraining order, you are now a felon under that federal statute. It's used 25 times a year, 30 times a year. Obviously, this is not an important not an important arrow in the quiver of law enforcement in America because it's basically never used. In contrast, if you look at the number of times that people are prosecuted under the other subsection of 922 G8, that would be 18 U.S.C. 922 G1, which is the felon in possession, it's like tens of thousands of people are convicted every year of this. It's thousands and thousands of cases. It's tens of thousands of cases over a period of years. It is a massive number of prosecutions dealing with that subsection, G1. And yet Merrick Garland shoved G8 in front of the Supreme Court because he wanted to be strategic. He wants to hurt the Supreme Court's credibility. He wants to force them to repudiate the Second Amendment. He wants to force the Supreme Court, if he has his druthers, to repudiate the Nyserpa versus Bruen methodology, which is really the Heller methodology, readopted by Bruen of text first, shift the burden to the government to show a historical analog, and that's very difficult to do. So anyway, Merrick Garland picked the really irrelevant part of 922G, the one that's never used. That would be subsection 8, as opposed to 1. So here's the thing. The Supreme Court still has plenty of time in its term that begins, or just began in October, first Monday of October. Every Supreme Court term begins the first Monday of October, and that it ends really the last day of June or so. So anyway, there's still ample time for the Supreme Court to take new cases for the 2023-2024 Supreme Court term. Now, Merrick Garland has just asked that the Supreme Court take the Range case, but hold it in abeyance. So they've sought cert, but saying, you don't need to decide this. And here's why, and this is, I think, a big thing that Merrick Garland said that's going to blow up in his face, and you'll see why. He wrote on page 7 of his brief to the Supreme Court, this Supreme Court should not leave the decision below, that's the Third Circuit decision that says that nonviolent felons have gun rights still, should not leave the decision below in place, but because the Supreme Court is already considering a closely related Second Amendment issue in United States versus Rahimi, plenary review is not warranted of the Range case at this time. The Supreme Court should instead hold the petition in the Range case for a writ of certiorari pending its decision in Rahimi, and then dispose of the petition in range as appropriate. You see what's happening here? But here's the problem. Merrick Garland ran out of time. He had to seek cert or not seek cert. If I were Merrick Garland, I would not have sought cert. I would have let the range case stand and then deal with it later. But instead, he's now sought cert. Now, this gives the Supreme Court the opportunity to take the range case, and now they get to analyze 922G1, which I think they're going to look very carefully at trying to give someone like Brian Range his gun rights back or make sure he never loses them on something that is clearly a malum prohibitum, nonviolent crime. So that's a very favorable, potentially mitigating factor against any possibility that a decision in the Rahimi case could go off the rails and gut somehow the Nysurpa versus Bruin interpretive methodology of applying and interpreting the Second Amendment. So I think there's a very good chance that the Supreme Court's going to grant cert to Range, and hear this term, both Range and Rahimi. Now, if you also add, because I just did a video, and sometimes, as I told you, these bricks get put together to build a wall around our rights. That's how lawyers put together cases. You build a brick of a law, a brick of a fact, bricks of fact, and then lo and behold, you have a whole legal case that wins for hopefully your client. So here, I just did a video explaining how I think it is conceptually possible and makes a lot of sense, both for Mr. Rahimi, who could benefit from shorter criminal sentences in, let's say, the state system, where he's, I believe, has been indicted on 5 or 6 counts of violent-related actions. He could benefit from cutting a deal with the district attorney, Phil Sorrells, in Tarrant County, Texas, the district attorney down there. And the reason why I say that is if there's a deal cut between the district attorney in Tarrant County, Texas, and Mr. Rahimi and Mr. Rahimi's lawyers, they'd have to work that out. The details, that's up to them. But the point is, conceptually, if they were to do that, they wouldn't moot the Rahimi case. Now, here's the key. You may say, the Supreme Court has to resolve these issues. Yes, but that might give the opportunity for the Supreme Court to say, look, the Rahimi case is clearly a difficult case. It's odious. We see what Merrick Garland is doing. We don't like to be gamed like this by Merrick Garland, the Department of Justice. So we have an opportunity to grant a dismissal based on mootness in the Rahimi case, and we're still going to have the opportunity in this 2023 to 2024 Supreme Court term to be able to decide the standard of basically who loses their gun rights under 18 U.S.C. 922G. Why? Because they're still going to have the Range case to decide. So basically, by Merrick Garland seeking cert in the Range case now, it's going to give the Supreme Court more options to look for a way to, let's say, dispose of Rahimi. Now, we haven't talked about all the different ways of disposing of the Rahimi case. There are other ways of disposing of the Rahimi case without even touching figures with the Second Amendment. For example, there's extremely powerful due process clause arguments in the Rahimi case that the Supreme Court could go with, dealing with the 5th and the 14th Amendment instead of the 2nd and the 14th Amendment. Likewise, there's also a very powerful Commerce Clause argument in the context of the Rahimi case that says that Congress simply lacks the Article I powers and authority to go out there and enact this law under 18 U.S.C. 922G8 because domestic violence restraining orders are very much a localized police matter and have nothing to do with interstate commerce in any respect, and therefore Congress lacks the authority to even enact 18 U.S.C. 922G8, regardless of the Second Amendment, and therefore the Supreme Court has different avenues of getting rid of the Rahimi case without even having to decide on Second Amendment grounds. Keep in mind, this is exactly what the Supreme Court did in another Second Amendment case several years ago. That would be in Nysurpa versus the City of New York, where they decide the case had been mooted out by the actions of New York City and New York State, and therefore that case was resolved at the Supreme Court level by saying that this case is moot. Therefore, we, the Supreme Court, lack jurisdiction because we no longer have a live, active case in controversy, so we no longer have Article III jurisdiction over this case, and they dismissed Nysurpa versus City of New York on grounds other than the Second Amendment. And there, my only point is that now that this Range case is before the Supreme Court, it's going to give the Supreme Court, in some ways, more incentives, more options, more ways to consider ways to dispose of the Rahimi case in a way that's not nearly as damaging, potentially to Second Amendment rights as some other cases. So the idea really is this allows the Supreme Court to decide perhaps potentially range, which is a much more favorable fact-based case for the Second Amendment, and dispose of Rahimi on non-Second Amendment grounds in some way. I just want to make one observation about the Department of Justice's brief as to what they're saying as to why cert should be granted. You're not going to believe this, but the Department of Justice is, of course, arguing interest balancing tiers of scrutiny again. On page 6 of their cert petition, I'll put a link to it down below. They're, of course, talking about dealing with the constitutionality of 922 G1, threatens public safety. Again, the Supreme Court has already said many aspects of the Bill of Rights threaten public safety, but that's the price we pay to live in a free society. For example, the whole point of the Bill of Rights is to make the lives of police and government harder to put people in prison. The Fourth Amendment that restricts searches and seizures is supposed to make the jobs of the government and police harder to search your home. That is not a bug in the system. That is actually a feature. And making it hard to deprive people of their ability to keep and bear arms is not a bug in the system. It's a feature. And of course, Merrick Garland, the Department of Justice, don't think we have a right to have any guns at all, and they express it quite the case. Beyond that, here's crazy talk. You're not going to believe this, but on pages 13 and 14, just to go how extreme the Department of Justice is being here, we can do a deeper dive later, but for now, just keep this in mind. They're literally using laws that forbid the cutting down of cherry trees as a basis to take your rights away from you under the Second Amendment. This is what they write on page 13 and 14. The Department of Justice and Merrick Garland says, quote, "In England before the founding, felons had no right to keep and bear arms. The standard penalty for a felony was death." Cite to William Blackstone. That punishment extended even to nonviolent felonies, such as, ready for this, cutting down a cherry tree. I'm kidding you not. Cutting down a cherry tree is an analog law that Merrick Garland intends to use to deprive you of your right to keep and bear arms if you're convicted of jaywalking or some other nonviolent felony as they define it. Because again, all this is malum prohibitum stuff. They just make stuff up and say that indeed you can't have a gun because we say so. And I'm sure that going on YouTube to express views that they don't like probably also at some point will constitute a nonviolent felony that you will lose your gun rights to. I'm sure that is where a lot of people on the left would like to go. So the bottom line is this. I think Merrick Garland has made a strategic blunder in seeking cert and range for a whole host of reasons. The biggest ones I've articulated on this video. I think there are actually others as well. But for the moment, we're just going to see how this dynamic plays out between the Supreme Court, the resolution of the Rahimi case, whether it's done on Second Amendment grounds or otherwise, and of course, the relatively sympathetic facts for the Second Amendment in the range case. So all of this is getting very interesting, leading up to a very interesting 2023-2024 Supreme Court term for the Second Amendment and those who support the right to keep and bear arms. So, all right, folks, hope you learned a little bit something here today about this inside baseball of the Supreme Court litigation. If you haven't subscribed, please do so. And don't forget to follow me on Twitter or X at 4Boxes Diner. And we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.